Prime Minister's question time. The table has been advised that PQB 213 will be replied by the Honourable Prime Minister, time permitting. I now call Honourable Hakim.
B158.
Mr. Speaker, sir, in accordance with Section 6 of the Ports Act, the administration of the affairs of the Mauritius Ports Authority is vested in a board which shall perform, exercise and discharge the functions, powers and duties of the authority. Furthermore, in accordance with Section 8 of the Ports Act, the Director General shall, inter alia, be responsible for the execution of the policy of the Board of the MPA and implementation of its regulatory and control functions. In addition, the Ports Act provides for the Director General to act in accordance with such directions as may be received from the Board. Following the retirement of the former Director General, Mrs. ABR, holding the substantive post of Deputy Director General, was assigned the duties of Director General in an acting capacity as from 4 February 2022, pending the filling of the vacancy and appointment of a substantive Director General. Mr. Speaker, sir, I am informed that the then Chairperson of the MPA received on 20th of December 2022 an anonymous letter sent to his residential address regarding a complaint against the Acting Director General of the MPA. The letter contained serious allegations against Mrs. ABR for the leakage of confidential information of the authority to unauthorized third parties. I am further informed by the Commissioner of Police that on 21st December 2022, the then Chairperson of the MPA reported the matter to the police. On the same day, Mrs. ABR was arrested and was brought to the CCID for enquiry. With her consent, her cellular phone as well as office laptop were secured for examination by the police IT unit. On the same day, her residential premise was searched. She was thereafter released on parole and was required to call at the CCID the next day for further investigation. Mr. JNPC, driver at the MPA and attached to Mrs. ABR, was also interrogated and he was subsequently allowed to go. Mr. Speaker, sir, in view of the position of authority occupied by Mrs. ABR, and in order not to jeopardize the good running of the police inquiry, on 23rd December 2022, the board of the MPA requested Mrs. ABR to step down and proceed on leave with immediate effect until completion of the police inquiry. Additionally, the board approved that Mrs. ABR would be entitled to all benefits as Deputy Director General. The latter accepted the decision of the board and proceeded on leave as from 24th December 2022. The board of MPA also approved that during her absence on leave, Mr. SJ, Deputy Director General, would be assigned the duties of Director General. In the meantime, on 1st of April 2023, an anonymous cover containing a set of WhatsApp messages allegedly exchanged between Mrs. ABR and Mr. AM, as well as a honorable member of the House, was received at the CCID by post. Following receipt of this document, Mrs. ABR was convened at the CCID on 24th and 28th April 2023. She was interrogated in the presence of her counsels and was confronted to the WhatsApp messages. Mr. Speaker, sir, on 19th of July 2023, the board of the MPA took note of a report dated 26th of May 2023, prepared by the Manager of Audit and Investigation of the authority at the request of the then Chairperson, who handed over to the manager of audit and investigation the anonymous letter and the exchange of WhatsApp messages. The latter was requested to correlate the information in the WhatsApp messages and the activities and decisions taken at the MPA. As the report confirmed a strong correlation, the board agreed that it be submitted to the police. The report was transmitted to the police on 20th of July 2023, and on the same day, a team from the CCID called at the MPA to take a statement of the manager of audit and investigation. On 21st July 2023, the board of the MPA decided, after obtention of legal advice and taking into account the security implications relating to the matter and the need to protect the interests of the authority, that Mrs. ABR would continue to be on leave pending completion of the inquiry, and she was accordingly informed. As regards legal advice received, it would not be appropriate to disclose same. Mr. Speaker, sir, I am informed by the Commissioner of Police that during the course of investigation, it came to light that in or around the years 2021 and 2022, Mr. AM posted confidential information pertaining to the MPA on his Facebook page, which led to believe that he might have received confidential information from an unauthorized source. On 7th of August 2023, Mr. AM was interrogated in the presence of his counsel, and he claimed his right to silence throughout all the questions put to him. On the same day, by virtue of a search warrant, his residence was searched. His cellular phone was secured for IT examination. He was allowed to go, subject to him being available for further inquiry. On 8th of August 2023, in the presence of Mr. AM and with his consent, his mobile phone and Facebook account were examined. Moreover, on 22nd of August 2023, the manager of the port environment of the MPA was interrogated in order to ascertain whether the documents and information retrieved from the WhatsApp messages and the Facebook account of Mr. AM were of confidential nature. The manager of the port environment confirmed that some of the documents were of confidential nature and could not be shared to an authorized person. On 28 February 2024, Mr. AM was convened for further inquiry and he was interrogated in the presence of his counsel. However, he claimed his right to silence. He was allowed to go thereafter. The inquiry has disclosed that Mr. AM might have committed the offense of possession of property bearing mark of third party in breach of Section 41 of the Criminal Code. On 5th of April 2024, he was provisionally charged before the District Magistrate of Port Louis South Court, and as there was no police objection, he was released on bail after furnishing a surety of 5,000 rupees and entered into recognizance of 10,000 rupees on his own name. The police inquiry is ongoing. Thank you.
The Honourable Prime Minister mentioned the charge laid against 1 AM. May I know from the Honourable Prime Minister what is the provisional charge laid against Mrs. ABR?
Well, I never mentioned any provisional charge against Mrs. ABR.
So the Honourable Prime Minister, who is also a lawyer, knows that the police is required to lay a charge when the police has reasonable suspicion that an offence has been committed. So there's a point the Honourable Prime Minister agree that in this case, the police has no reasonable suspicion that Mrs. ABR has committed any offence whatsoever.
Mr. Speaker, I just answered the inquiry is ongoing.
Is the Honourable Prime Minister aware that under Section 64 2B of the Workers' Rights Act, an employer can terminate the employment of a worker if that worker has been convicted by a court of first instance. In this case, there's no conviction. There's not even charge laid. So under what legal basis can the Mauritius Ports Authority take disciplinary sanction against this Mrs. ABR?
But the employment has not been terminated in this case.
We're talking about ABR, who, as you rightly pointed out, was acting Director General of MPA. Senior most officer with unblemished record, and the Honourable Prime Minister finds it normal that MPA should be deprived of the skill and expertise of its senior most officer for 15 months on the basis of a mere anonymous letter?
Well, it is for the MPA to take a decision, as they have done. There has been leakage of very confidential documents and information. And it is for MPA to see to it according to what they have as evidence, and they have transmitted to the police. As I say, inquiry is ongoing. I do not know what is going to be the conclusion of the inquiry.
Honourable Prime Minister agrees that indefinitely this lady can be suspended.
I am not agreeing to anything. What is this? Don't put in, you don't understand what I am answering. Listen carefully to my answers. I am saying the inquiry is ongoing. I don't know about where they, I mean, there have been, of course, information that has been gathered by the police, but I leave it to the police and I leave it to the board to take a decision.
Next question, Honourable Tool.
B159.
If I may, I have listened very carefully to your ruling that you gave at the outset, and let me underline that I'm in no way challenging your ruling or asking you to sit on appeal against your own ruling. That is not what I'm doing. And I'm sure you
don't make any literature. Go straight to the point of order.
Nice to you.
Which point from the standing order?
Basically referring to Erskine May, and which is basically authority for proceedings here when it's not referred to in our standing orders. Because you will see Erskine May says that as regards the rule of sub judice, it's clearly at paragraph 24.74 of Erskine May. It basically says here that the rules, and I quote, the rules governing sub judice do not apply to bills, etc., but it is recognized that Parliament should not generally intervene in matters where the decision has been delegated, etc. Then it goes on to say, for matters that will be heard when charges have been preferred, and matters have not been heard yet, but charges have been preferred and will be heard, it is sub judice. So what I'm trying to say, Mr. Speaker, sir, it is not necessary for a case to have started. The fact that charges have been laid and it is therefore to be heard, it is practice, according to Erskine May, that such matters are totally sub judice. There you go.
I've listened to your point of order. This is my ruling. I agree. Please listen to the ruling. Be polite. The ruling is the following. I rule that this question is admissible. Please go ahead.
They should not be making delaying tactic.
Go ahead.
Delaying me in my sir. Ask the one behind you about delaying tactic. He's an expert. Mr. Speaker, sir, I refer the honourable member to my reply to parliamentary question B500 made during the sitting of the National Assembly on Tuesday, the 16th of May 2023. In fact, the House was made aware that a shockingly huge sum of money was concealed in two premises of Dr. Navin Chandra Ramgoolam, GCSK, FRCP, former Prime Minister, situated at Sir Sivsagar Ramgoolam Street, Port Louis, and the other at River Walk, Floreal. I am informed by the Commissioner of Police that following information gathered by the police, the latter carried out searches in both premises during the night of Friday, 6th of February 2015 to Saturday, 7th of February 2015 by virtue of search warrants issued by the District Magistrate of Port Louis and QPIP courts respectively. During the course of the searches, money both in local and foreign currencies, estimated at that time to amount to around 230 million rupees, were secured from his premises and coffers. The details thereof are as follows: 3,161,411.22 US dollars, amongst which were 17 bundles, each containing 1,000 notes of 100 US dollars, 57,956.14 pounds sterling, 558,808.19 euros, 73,970 Indian rupees, 52 Malaysian ringgit, 184 Singaporean dollars, 8,500 Hong Kong dollars, 300 South African rands, 100 Denmark kroner, 5 Canadian dollars, 4,000 Australian dollars, 3 UAE dirhams, and also 102,174,065 Mauritian rupees. It is to be noted that the 17 bundles, each containing 1,000 new, serially numbered 100 US dollars, were sealed, shrink-wrapped, and not yet put in circulation. Additionally, I am informed by the Commissioner of Police that during the searches, the police secured bank cards, privilege cards, and some other items. Mr. Speaker, sir, the Commissioner of Police has further informed that on Saturday, 7th of February 2015, Navin Chandra Ramgoolam was arrested and a statement was recorded from him. He was provisionally charged before the Bail and Remand Court for the offence of money laundering in breach of sections 3(1)(b) and 8(1) of the Financial Intelligence and Anti-Money Laundering Act of 2002. He was released on parole on the same day and had to attend Upper Plain Williams District Court on Monday, 9th of February 2015 to do the needful in relation to the surety and recognizance. An inquiry was initiated into the case. During the course of the investigation, the assistance of the Federal Bureau of Investigation was sought with a view to obtaining information on the tracking of the new notes serially numbered in 17 bundles of 100 US dollars. After completion of inquiry, the case file was referred to the Office of the Director of Public Prosecutions, which on 20th of October 2017 advised prosecution against Navin Chandra Ramgoolam before the Intermediate Court on an information containing 23 counts charging him with willfully and unlawfully accepting payment in cash on 23 different occasions in breach of Section 5 and then Section 7 and 8 of FIAMLA. Mr. Speaker, sir, the Office of the Director of Public Prosecutions had also advised that the matter be referred to the then Integrity Reporting Services Agency, which was established under Section 9(2) of the Good Governance and Integrity Reporting Act, and the Mauritius Revenue Authority for possible revenue offences which may have been committed by Navin Chandra Ramgoolam. Accordingly, on 23rd October 2017, the then Commissioner of Police referred the matter to the Ministry of Financial Services and Good Governance for onward referral to the then Integrity Reporting Services Agency and the Mauritius Revenue Authority for appropriate action at their respective end. Moreover, mutual legal assistance had also been sought from concerned foreign authorities through Attorney General's Office of Mauritius. I am further informed by the Commissioner of Police that on 15th November 2019, the Intermediate Court Criminal Division dismissed the 23 counts of the amended information against Navin Chandra Ramgoolam based on the motion of his counsel to the effect that the prosecution could not provide the particulars of the date of the alleged offences and the identity of the persons who allegedly made the payments, and that the charges therefore failed to meet the test of certainty which is required under the Constitution in order to allow the defense to know the case it has to meet and to be adequately prepared to meet the case for the prosecution. However, the Office of the Director of Public Prosecutions appealed against the ruling to the Supreme Court. Mr. Speaker, sir, on 30th of August 2022, the Supreme Court of Mauritius allowed the appeal, quashed the ruling of the Intermediate Court, which had dismissed the amended information against the accused, and remitted the matter to the Intermediate Court. In this context, the relevant extracts of the Supreme Court judgment are as follows. I quote, "We note that the learned magistrates did not consider the nature of the offence created under Section 5.1 of the FIAMLA, which is limitation of payment in cash, when addressing the issue as to whether it was material to provide particulars of the identity of the payer." Another part of the judgment, there was no dispute that all the elements of the offence were indeed averred in the information. And then it was also stated that the learned magistrates failed to make a distinction between the elements of the offence which need to be averred in the information and the material circumstances in the form of particulars. And it was also stated that no prejudice could be caused to the respondent by the non-communication of the particulars. The materials provided will allow the defense to know well before the trial the evidence which the prosecution intends to adduce, and the defense will have the opportunity to rebut same by means of cross-examination or otherwise, unquote. Consequently, the Supreme Court found that all the grounds of appeal were well taken and allowed the appeal. Mr. Speaker, sir, Navin Chandra Ramgoolam then sought leave before the Supreme Court to appeal to the Judicial Committee of the Privy Council against the judgment of the Supreme Court. On 8 February 2023, the application was set aside by the Supreme Court with cost. In this regard, I quote what the Supreme Court said, "We therefore conclude that the decision of the Supreme Court does not bear the characteristics of finality, and as such, an appeal cannot lie against it to the Judicial Committee of the Privy Council," unquote. Subsequently, Navin Chandra Ramgoolam applied for permission to appeal before the Privy Council against the judgment of the Supreme Court of the 8th February 2023. On 30th of June 2023, the Judicial Committee of the Privy Council decided not to grant special leave to Navin Chandra Ramgoolam to appeal against the judgment to the Supreme Court of the Supreme Court, stating, and I quote, "There is no appeal as of right in this case. Permission to appeal is refused. There is no risk that a serious miscarriage of justice has occurred," unquote. My God. Thus, the case was referred to the Financial Crimes Division of the Intermediate Court for trial. However, counsel for Navin Chandra Ramgoolam made a motion that in the absence of any directive from the Chief Justice, pursuant to Section 80A, subsection 2 of the Courts Act, there has been an erroneous transfer of the case from the Criminal Division of the Intermediate Court to that of the Financial Crimes Division of the Intermediate Court, and that as such, the Financial Crimes Division does not have jurisdiction to hear the case. On 3rd of April 2024, the magistrates of the Financial Crimes Division ruled that the Financial Crimes Division of the Intermediate Court does have jurisdiction to consider the case. Mr. Speaker, sir, the case is accordingly proceeding before the Financial Crimes Division of the Intermediate Court and has been fixed for continuation on the 6th of May 2024.
Merci, Monsieur le Président. L'honorable Premier ministre peut-il informer la Chambre de la procédure adoptée dans les cas où de nouveaux billets de banque sont émis et quelles sont les implications eu égard aux billets de $9 trouvés dans les coffres du docteur Navin Ramgoolam?
Monsieur le Président, je suis informé que les nouveaux billets de banque sont émis exclusivement par les banques centrales des pays dans la devise propre à chaque pays. Dans le cas de Maurice, la Banque de Maurice place la commande des nouveaux billets. À leur arrivée, en paquets laminés et numérotés en série, soit par voie maritime ou aérienne, ces nouveaux billets sont acheminés sous faute escorte de la Special Mobile Force vers la voûte de la Banque centrale, où ils sont stockés selon leur dénomination respective avant d'être émis selon une planification préétablie. Concernant les nouveaux billets de dollars, ils sont émis exclusivement par la Federal Reserve Bank des États-Unis. Dans le cas de nouveaux billets de dollars retrouvés dans les coffres forts du docteur Navin Chandra Ramgoolam, il s'agit de 17 paquets, chacun contenant 1000 unités de $100 neufs, emballés sous film rétractable et jamais utilisés. Chacun peut en tirer sa propre conclusion. La presse locale, Monsieur le Président, a fait état d'une déclaration du docteur Navin Ramgoolam où il a affirmé que l'argent retrouvé dans ces coffres forts, y compris les liesses de dollars flambant neufs, provenant de ses per diem, de son salaire et de donations. Si tel est le cas, et si le docteur Navin Chandra Ramgoolam dit la vérité, il n'a qu'à le prouver, bien sûr. Son partenaire, l'honorable Béranger, peut-être pourrait l'aider dans ce domaine. En tout cas, Monsieur le Président, Monsieur le Président, afin de prouver que le docteur Ramgoolam n'est pas en train de dire la vérité, la poursuite devra prouver que les billets de dollars flambant neufs n'ont jamais été en circulation. Et je crois qu'il n'est pas difficile, à mon avis, de prouver cela. Monsieur le Président, le pays aussi doit connaître la vérité. Et c'est bien qu'aujourd'hui nous avons l'honorable Shakil Mohamed qui est le leader de l'opposition. Parce que feu Youssouf Mohamed avait si bien dit, « Moi pas capable de faire miracle ». Cette affaire, et je dois ajouter, Monsieur le Président, cette affaire, c'est le tip of the iceberg. Nous allons voir, l'avenir nous dira qu'est-ce qu'il y a d'autre encore. Merci.
Thank you, Speaker. In his reply, Honourable Prime Minister made mention of bank cards. Can Honourable Prime Minister give more details as to the bank cards secured by the police? Thank you.
Well, Mr. Speaker, sir, I am informed by the Commissioner of Police that 27 bank cards were secured, namely 9 American Express cards, 8 HSBC cards, 4 Lloyd cards, 3 Santander credit cards, 2 MCB credit cards, 1 Barclays Gold Visa card. These cards offer high spending limits and are exclusively crafted for their holders to enjoy exemplary privileges on shopping, travel and dining and to complement exuberant lifestyle. Et je dois ajouter, Monsieur le Président, il faut voir comment ces cartes ont été utilisées, quel genre de montants, quel genre de dépenses ont été faites. Et il faut pouvoir justifier ces montants aussi. L'avenir nous dira encore plus sur le mystère de ces cartes.
Thank you, Speaker. In view of the reply of the Prime Minister, can the Honourable Prime Minister state whether it can be concluded that the former Prime Minister is having recourse to delaying tactics in this matter before our courts?
Well, I cannot make any conclusion. However, the facts and acts are that I think they are there to ascertain that so far there have been a number of frivolous motions that have been presented in our courts. And it is for each and every one to interpret those frivolous motions that have been made. To me, clearly, it is a delaying tactic. And I can recall, Mr. Speaker, sir, I can recall dans l'histoire politique, à l'époque où le remake était mis à fin, et la raison qui a été invoquée à l'époque par l'honorable Paul Béranger, que j'étais en train de faire du delaying tactique dans le cas de Maître Paul. Delaying tactique. Alors que moi, je voulais à tout prix que mon affaire soit prise dans les plus brefs délais pour que justice soit rendue. Hein? Mais je comprends, Monsieur le Président. Avec l'âge, peut-être on ne reconnaît plus quel genre de dealing tactique est en train de se faire. Mais on verra.
Order. Honorable Béranger, I heard you. Order, what is happening? I am on my feet. Order, both sides of the House. Both sides of the House. Honorable Béranger, I heard you saying sauvage. You said sauvage? Are you prepared to withdraw the word? No. Are you prepared to apologize? Are you prepared to move? And I am naming you. I am naming you. You are not God. You are not God. I am naming you. You are a simple human being. I'm naming you. Please, Sergeant at arms, collect this man. Collect this man. Collect him. Sergeant at arms. Sergeant at arms and all police officers. You are under your duty, police duty. Collect this man. Collect this man. He may be mad. Collect him. He may be mad. Collect him. Collect him. Send him to hospital. I am also naming the Right Honorable Bhagwan. I'm naming him. Sergeant at arms, collect this man. Collect him. Collect him. Pluck him out from this chamber. Please, Sergeant at arms. He may be mad. He may be mad. This is a sick man in Parliament. This is a sick man in Parliament. You are mad. Go out. Go out. Go out. You are mad. You are mad. Go out. Go out. Go out. Sergeant at arms. Go out. Go out. Order. At this stage, let me suspend the sitting for lunch. 1 hour, 1.5 hours.